Accused, you are convicted twice.
Yes, my lord.
Page number
My lord,
20.
page number 40.
This has become a habit for you now.
Yes, my lord.
Coming here,
Ample
getting it
opportunity has
set
been
aside.
given, my
My lord, I have not.
Back.
My lord, that is not the reason.
Yes,
My lord, that
sir.
is not the reason. My lord. I just, yeah, 2 minutes I brief. My lord.
Yes, sir.
My lord, this is a gang rape offense.
Yes,
No,
sir.
no medical proof at all. No
That is-
recovery.
That is evidence.
Yeah. That is why I have not come before this honorable court without any valid reason. My lord.
Yes.
Not kindly read the page number 40,
Hmm.
para 25, my lord. May I read? My lord?
Page.
40 of the petition.
Ah.
The perusal of the order sheet dated 16/1/24 would show that PW19 was present since morning. The learned counsel representing the accused number 3 during the afternoon sessions appeared before the court and sought time for further cross-examination of PW19 on the ground that he requires time to produce CD from 26/10 to 2014 and 5/11/2024, and thereafter he submitted CDs are not available, and he requested the court to direct the PW19 to bring the other CDs, and the case is adjourned on 9/11/23. Actually, this is not correct, my lord. On 16/11, I have cross-examined. Kindly look at the page number 146 of additional documents.
1611 ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ಸರ್, 19th ಮಾತ್ರ.
ಹೌದು ಸ್ವಾಮಿ, 16 ನಾನು ಕ್ರಾಸೇ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. 16 ಟೈಮ್ ಕೇಳಿದೆ, 19 ಟೈಮ್ ಕೇಳಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. 16 ನಾನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಸಂಜೆವರೆಗೂ ಟೈಮ್ ಆದ ನಂತರ ನಾನು ಹ್ಯಾವ್ ಸಾಟ್ ಫರ್ದರ್ ಟೈಮ್ ಫಾರ್ ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. I put the order sheet. Order sheet shows that.
Where is the order sheet?
Order sheet is in page number 147 in the additional documents filed on 5/7/24. 146 no.
146 or 7 now?
146 no. Dated 16/1/24. Sixth line from the bottom, Lord. PW19 is present and further partly cross-examined by the counsel for the accused number 3. The learned counsel representing the accused number 3 praised time for further cross of PW19. The PW19 stated that he is having CD from 26/10/2014 to so and so, and submitted that further CDs are not available. Though he made efforts to secure other CDs, but he is not unable to get the same. The counsel representing the accused number 3 submitted that the court to direct the PW19 to bring other CDs. The PW19 is directed to make efforts to get the CDs. For objections of securing this application filed by accused number, other accused had filed the recall application. That is a different matter. Those were rejected, Lord. On that day, I have cross-examined till evening, and it was adjourned to 19. On 19, one of my senior was admitted in a hospital. The yesterday night, on 18th night, I was in the hospital. On 19th, I appeared before this honorable coordinate bench of this honorable court in an EP 11 of 2018, Lord. So therefore, I could not go and cross-examine the PW19. The reasons assailed by the honorable trial court is not correct, Lord. And as far as the PW20 is concerned, Lord, PW20 out of
You want 6, 7, 8, 9, 11?
Lord, I don't press 6 and 7, Lord. I
7, 8, 9,
7 and
10.
8 are required, Lord, because they say that they are the pawnbrokers who pledged the accused pledged the stolen property, stolen
When
gold.
did you cross-examine them initially?
My lord, that day I have clearly submitted. I was under serious.
Sir, 8 and 9 ಯಾವಾಗ ಮಾಡಿದ್ರಿ ಮುಂಚೆ?
ಅದು 2019 ಅಲ್ಲಿ ಮಾಡಿರೋದು, ಆಮೇಲೆ ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದು ರಿಮಾಂಡ್ ಆದ್ಮೇಲೆ ಆಪರ್ಚುನಿಟಿನೇ ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ 8 and 9ಗೆ. ಒಂದ್ ದಿವಸ ಅವ್ರು ಬರ್ತಾರೆ, ಅವತ್ತು ಹುಷಾರಿಲ್ಲ ಅಂತ ಅನ್ನೋ ಕಾರಣ ಕೊಟ್ಟಾಗ ಅವರನ್ನ ಇಟ್ ಇಸ್ ಟೇಕನ್ ಆಸ್ ಡೆಲ್.
Yes, government.
My lord, not only 3 times, my lord. There are several times they have took, my lord.
After the remand order?
Yes, my lord. Kindly see, my lord, page number 20. Page number 30, in page number 30, order sheet of the order page number 11, para number 20. The learned counsel representing the accused number 3 during the course of his argument contended that on 29/11/23, he was suffering from ill health and same continued till 1/12/2023. He was unable to attend the court and cross-examine PW 6 to 8, and hence the cross-examination of PW 6 and 7 by accused number 3's counsel is taken as nil. The per usual of the adu one date aitu. Amele next para number 21. Further, the per usual of the order sheet dated 29/11/2023 would clearly shows that on the above said date, the counsel representing the accused number 3 was not present. Though the matter was set down for cross-examination of PW 6 and 7.
ಇದೆಲ್ಲ ರಿಮಾಂಡ್ ಆದ್ಮೇಲ
Yes, my lord.
That is on one stretch, my lord. 28 to 11.
ಆಮೇಲೆ para
20
number
not
22 on 1/12/2023 would clearly shows that PW 8 and 9 were fully cross-examined by accused number 2 and same was adopted by the counsel of the accused number 1 and 4. On that particular date, when the matter was posted for cross-examination of PW 8 and 9, the counsel for the accused number 3 remained absent. Again, my lord, on 4/12/2023 would clearly shows that on 4/12/2023, PW 11 was fully cross-examined by the counsel for the accused number 3.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
My lord. My lord, I don't press as far as the 6 and 7, my lord, 6 and 7 is concerned. I am satisfied with the cross examination. But 7 and 8, my lord, my lord, your lordship is know that our difficulty is engaging in other trial courts.
No.
I was held up in other trial court.
That is
My lord, my lord, my lord, kindly-
there are already
my lord,
orders passed
my
by
lord,
this court for
2 times
conclusion of the
convicted, my
my
lord.
lord,
2
my lord,
times.
earlier 2 occasions, this state has state has conceded before this honorable court that yes, we have not given opportunity to the accused persons. Therefore, the matter has been remitted back.
Correct.
That observation has been made in the
Yes,
earlier
sir.
orders.
Yes, yes.
And PW 20 and 19, there is no question that the reason assigned by the honorable trial court is not correct because on 16 fully I have cross-examined and they had sought time to produce the CDs. On inevitable circumstances, I sought for time for further cross-examination.
No, sir.
As far as the PW 19
Anything
is,
else, sir?
Lord, kindly, Lord, your lordship's judgment.
I know, sir. Same
Yes,
case,
yes, my
I
lord,
know,
yes.
yes.
Lord, it says,
That is, I've said-
unless there is an intention to drag the proceedings. My lord, I am in,
What else is this, sir?
my lord,
I will answer intention to drag the proceedings only.
my lord, but no reason, my lord.
No, no, sir.
My lord, this is pro bono cases, my lord. They are languishing in jail. We have not taken fees and appearing just to assist the court.
Is that the ground?
My lord, no, my lord.
Can that be
That
the
is
ground
not,
for
my lord, why
interference?
should I drag, my lord? I am in jail. In fact, I wanted to dispose of before the early presiding officers. Therefore, my lord, kindly look at the other cross-examination of the other witnesses, my lord. I have cross-examined, other accused have been adopted the same. No, that becomes very painful for me. I have never intended to drag the proceedings, my lord. I have never intended to drag the proceedings. My lord, one more important aspect, my lord. 3 months, the date has been given by this honorable court to expedite the matter. The trial starts on 23/11/2023. It is ended. This taken as nil takes place on 19/1/2023. Within 2 months, I have cross-examined nearly about 13 witnesses, my lord. I leave it. I take the excuse. I don't take the excuse of this honorable court as far as the say PW 7 to 9, my lord. I don't press. If that accusation comes on me, I don't press. But as far as the 19 and 20, I have a case. The entire case relies upon PW.
You are 19 and 20.
The DNA expert, my lord. My lord, he does not collect the blood report from the accused, but he gives the report. He gives the report. He has not collected the blood from the accused. Only he collects the blood from accused number 1. But as far as he gives the report, as far as the accused, all the accused, including the accused number 3, that is the blunder has been committed by the investigation officers and even including the doctors, my lord, in this case. That is why observing all those material facts, twice the matter was remanded, not on any other reasons, my lord. That's because of these reasons. My lord, doctor says there is no single sign of forceful sexual assault. There is no sign of gang rape. This is the blunder case, my lord, as far as this 376D is concerned. And my lord, they say, the investigation officer says that, my lord, nothing has been there in the CD case diary. Yes, I have cross-examined. If your lordship allow me, I'll just read out. I don't want to waste this precious time of this honorable court, my lord. Investigation officer, not recorded, not even a single sentence in the case diary, my lord, he has brought before the court. He has not, Caesar, he has not recorded. Sending of the accused persons to the doctor, medical examination not recorded. Recovery not recorded. Arrest not recorded. He answers in the deposition, my lord. It is in the last sheet, my lord. Your Honor, your lordship may kindly peruse the answers given by the, that is the
Where is your application?
What?
Application 311.
Application. Lord, page number 49, Lord. I have, whatever I have submitted before this honorable court, as far as the dates of hearing are concerned,
Page
have
49
49, Lord. 49 to,
applications.
yeah, that is what the application, 311 application.
ಎಲ್ಲಿದೆ?
Page number 49 of the petition.
Documents. 49 to,
Annexure D, my lord.
1 minute. Application.
Yes, my lord. My lord, kindly look at the, but kindly look at the page number 52, my lord.
Nineteen and 20 ಯಾರು?
Yes, my lord.
Who is 20?
20 is the DNA expert.
19 ಯಾರು?
19 is the investigation officer. My lord, and PW 11, who conducts the medical examination, the accused says, my lord, she is a doctor. I am not aware, I am not expertised in conducting the medical exam,
Others have not cross-examined these witnesses.
They have,
but not so effectively.
they have cross.
But not so effective. No, I am not ready. I am not ready.
You have adopted their cross.
No, I am not adapted, my lord. I have not adapted. But they are depending on me, my lord, because others are DSLA advocates and therefore they have followed. They have adopted all my cross-examination. After this, even the trial court judge has appreciated my cooperation, my lord. In spite of
All
this,
that are not grounds to
not-
allow
not
the
ground-
application. sir.
I just,
Your aggrandizement will not result in allowing the petition.
please, my lord.
Yes.
Lord, page number 51, my lord. 51. Para 2. The accused number 3 submits that on 6/12/23,
Yes, not all the accused, this
one, I want,
medical expert, investigating officer and
my lord, that's
DNA expert is not exempt. It's a gang rape.
Let him produce the deposition, what he has done so far.
Where are the depositions?
depositions I have produced, my lord.
No, see, it's a case of gang rape. Others we have permitted, others have cross-examined. Individual conviction also can happen. It's not. So let him have one opportunity. 19 and 20 DNA experts are not examined. Most crucial examination.
Produce that, is not at least. given a
Madilla,
copy of
sir.
the-
After
Right,
remand,
most-
I have not, it is, the order is showing.
Crucial examination. It can tilt the case in his favor or against him, at least sentence. ಅಲ್ಲ ಆಗಿದೆ ಬಿಟ್ಟಿದೆ ಅದೆಲ್ಲ ಬೇರೆ.
The lordship can direct him to conduct on the same day.
Yes, my lord.
On the same day. let him
You should
conduct.
cross-examine
Yes,
everything. No
any-
last straw of opportunity.
Yes,
Because my lord, all opportunity has given my lord,
No, no,
later my lord on.
No, see, this petitioner had challenged it or what. Earlier ಮೂರ್ ಯಾರು ಮಾಡಿದ್ ನೀವಲ್ಲ.
ನಾನಲ್ಲ.
ಬೇರೆಯವ್ರು ಮಾಡಿದ್ದಾರೆ.
No, ಬೇರೆಯವ್ರು ಮಾಡಿರೋದು. ಬೇರೆಯವ್ರು ಮಾಡೋದು I have permitted in case of this Anil Kumar, who is accused number
3.
Anil Balgar.
ಸುಜಿತ್.
ಅಲ್ಲಲ್ಲ, this Anil Balgar accused number ಏನು?
ಸುಮ್ಮನೆ ಅದು ಇನ್ನೊಂದು ತಾವು ಕೊಟ್ಟಿರುವಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು 311 ಮೇಲೆ
ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ.
ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಅದು ಗ್ಯಾಂಗ್ ರೇಪ್.
No, ಅದ್ರಲ್ಲಿ 376.
302.
ಅದ್ರಲ್ಲಿ ರೆಡ್ ವಿತ್ 376. ಅದ್ರಲ್ಲಿ 311 ಯಾವ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಎಲೋ ಮಾಡಬಹುದು ಅನ್ನೋದನ್ನ ತಾವು ಎಲಾಬ್ರೇಟ್ ಆಗಿ explain ಮಾಡಿ.
Yes, sir.
Let him do it on the same day.
On the same day. There is something in what he says. He has not been permitted then. Yes.
My lord, 7, I don't press 6 and 7, 8 and 9, my lord. 8 and 9 and 11 who conducted the medical exam. I had
11, 19, 20. I will
20,
permit.
8 and 9, my lord.
ಏನ್ pawn brokers ತಗೊಂಡ್ ಏನ್ ಮಾಡ್ತೀರಾ?
My lord, earlier, they say that they that pledged the properties.
That will not take you anywhere. sir.
It proves the recovery, my lord. It proves the recovery. My necessity, my purpose would not.
Others have examined that. Don't worry about it. 11, 19, 20.
Agbost.
Yes, they are important. The petitioner,
At least one among them, my lord. 8 and 9, one among them. One among them, my lord.
that will not take you anywhere, sir. These three, yes, definitely they are required,
Please.
and cross-examination is a must.
Obligement.
Yes. The petitioner is before this court calling in question an order dated 13/2/2024 by which the concerned court rejects the application filed by the petitioner under section 311 of the CRPC seeking recall of the witnesses 6, 7, prosecution witnesses 6, 7, 8, 9, 11, 19, and 20 for further cross-examination. The petitioner heard so and so. The petitioner is accused number 3. He, along with other accused, get embroiled in a crime number 729 of 2014, initially for offences punishable under section 397 of the IPC. The police conduct investigation and file a charge sheet on the basis of certain add madra. The police during investigation on the basis of the statement recorded by the victim include offences under section 376D, 342, 392 and 506B of the IPC. The police conduct investigation and file a charge sheet against these petitioners on 25/1/2015. Since the registration of the crime, the petitioner is said to be in judicial custody. Twice over, the petitioner gets convicted of the offense, and twice over, he approaches this court in New Alvala. Where have you approached?
ಒಂದರಲ್ಲಿ ನಾನಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಯಾವ್ದದ ನಿಮ್ದು?
ಇಲ್ಲ ಅದರಲ್ಲಿ
ಯಾವ್ದು ನೀವು ಅಪೇರ್ ಆಗಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಯಾವ್ದು?
ಇವಾಗ ನಾನು ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಅರ್ಧಂಬರ್ಧ ಮಾಡ್ತೀವಿ. It transpires that the accused get convicted of the offense so alleged by an order of the concerned court. This becomes subject matter of criminal appeal 257 of 2019 connected with criminal appeal 21 of 2019. A coordinate bench of this court, in terms of its order dated 19th August 2019, allows the appeal on the score that the petitioners therein were not afforded full opportunity to cross-examine all the witnesses. Therefore, the order of conviction comes to be set aside and the matter was remitted back for an expeditious conclusion of the trial within 5 months from the date of receipt of the said order. Yet again, the other accused approached this court in Criminal Appeal 863 of 2022 and connected cases, challenging the order of conviction against those accused. Again, on the same ground that they were not permitted to be complete, they were not given the opportunity of complete cross-examination of prosecution witnesses. This court, by the following order, remits the matter back to the concerned court, directs conclusion of the trial within 3 months.
3 months.
Within 3 months from the date of receipt of the copy of the said order. The trial then commences. After the commencement of the trial and during its conduct, the petitioner files an application under section 311 of the CRPC seeking recall of PW 6, 7, 8, 9, 11, 19 and 20. This comes to be rejected by the impugned order, the rejection of which has driven the present petitioner accused number 3 in the aforesaid crime to this court, calling in question the said rejection. The learned counsel appearing for the petitioner would vehemently contend that the Dharanesh would vehemently contend that a cross-examination of the accused 6, 7, 8, 9, 11, 19 and 20 are imperative as they have not been completely cross-examined. He would further lay emphasis upon the cross-examination of 11, 19 and 20, who are the medical expert, the investigating officer and the DNA another
PW 20.
20 ಯಾರದು 20 ಯಾರು PW 20?
Doctor.
The doctor of the FSL who has rendered the report, the DNA report of, who is said to have been rendered the DNA report. The learned counsel would submit if there is ample evidence for the petitioner to get absolved of the offences as there are serious lacunae in the conduct of investigation by the investigating officer, and the examination of these witnesses would turn the tables in his favor. The learned HCGP would refute the submission to contend that the petitioners, each of the accused on one pretext or the other, are approaching this court, and twice the accused who were convicted were before this court, and this court has directed that the trial should be concluded within a time frame. Now the petitioner has come up before the court after losing the opportunity that is granted by the concerned court to cross-examine those witnesses now of whom he seeks further cross-examination today. I have given my anxious consideration to so and so. The afore narrated facts are not in dispute. The issue in the list is with regard to the offense punishable under section 376D, which would be an offense of gang rape. The petitioner is accused number 3. Several accused in the case at hand have intermittently accused number 3. The concerned court convicts the accused initially in terms of its judgment dated 2/11/2000, conviction and sentence dated 2/11/2018. This becomes the subject matter of challenge in Criminal Appeal 257 of 2019, which comes to be allowed by the following order, para 9 at page 10 memo. The reason for allowing and setting aside the conviction was that the accused were not given full opportunity to cross-examine the witnesses. The trial moves on. The accused are again convicted. The conviction again is called in question before this court in Criminal Appeal 863 of 2022 and connected cases. The appeal is allowed by the following order, page 22-23. Again, it is allowed on the score that merely because this court had directed conclusion of the trial within a time frame, it would not mean that the accused would not be given full opportunity to cross-examine the witnesses. Those were other witnesses. The petitioner, accused number 3, is again before the doors of this court on an application being rejected and filed under section 311 of the CRPC. The concerned court reasons it out that this court has directed conclusion of the trial within a time frame, and the petitioner has lost the opportunity that was granted to him on 16/11/2023 and 19/11/2023. The reason so rendered by the concerned court to deny further cross-examination read as follows, para 19-22, page 37-39 of the petition. The learned counsel would take this court through the order sheet maintained before the court to demonstrate that on 16/1/2024, he in fact did partially cross-examine those witnesses, and the finding of the court to deny the application is erroneous. The submission stands to reason on a perusal at the order sheet dated 16/1/2024. The witnesses that he seeks to further cross-examine are the medical expert who had conducted medical examination, i.e. accused number 11, PW 11, and the investigating officer, PW 19, and the DNA, the doctor who had rendered the DNA report from the FSL, who was PW 20. The learned counsel would project many instances where there are serious lacunae in the conduct of investigation by the investigating officer, all of which are necessary to be put in evidence put in cross-examination of these witnesses. Therefore, I deem it appropriate to permit the petitioner to further cross-examine accused number 11, 19, and 20, and not permit 6, 7, 8, and 9 as they were already cross-examined, and further examination of theirs would not turn anything, would not lead to any discovery of fact fact that would inure to the benefit of the petitioner. However, that same would not be with the accused number 11, 19, and 20, who appear to be imperative to be further cross-examined. The section 311 permits recall of witnesses or examination of documents at any stage during the trial. The purport of section 311 need not detain this court for long or delve deep into the matter. The apex court in the case of Varsha Garg versus so-and-so, 2022 SEC Online SC page 986, para 31 to 48. So has considered the purport of section 311 and its necessity to permit further cross-examination of the accused unless it is demonstrated by the prosecution that it was an abuse of the process of the law. Though the matter has twice reached this court and twice over the conviction of the accused is set aside, it is on the score that the accused were not permitted full cross-examination of prosecution witnesses. Again, it should not lead to this court on the same ground. Therefore, as a last straw of opportunity to the petitioner, I deem it appropriate to permit further cross-examination of PW 11, 19, and 20 on a date fixed by the concerned court. The cross-examination shall be concluded by the petitioner, by the counsel for the petitioner, without dragging the matter any further on the said date itself. For the aforesaid reasons, the following order. The petition is allowed in part. The denial of cross-examination, further cross-examination of 6, 7, 8, and 9 stands sustained. The denial of cross-examination of 11, 19, and 20 stands quashed. The concerned court shall permit further cross-examination of 11, 19, and 20. 11, 19, and 20, fix a date for such cross-examination. The petitioner shall conclude the cross-examination on the same date, and the concerned court shall thereafter regulate its procedure for passing necessary